Now, in the Supreme Court today, the All India Muslim Personal Board, in fact, filed a reply stating that the petition against the Muslim Law Board is not maintainable. Now, the Supreme Court likely to hear the matter on the 30th of March.
This is again a reiteration of the Muslim Personal Law Board's earlier AG position. But what is very interesting is, again, this time around, the Muslim Personal Law Board has reiterated its opposition to judicial intervention on the sticky issue of triple talaq. It goes on to cite a host of reasons, but the main emphasis that it tries to dwell on is the fact that this is an issue which is protected under Article 25 and 26 of the Constitution, which is namely the freedom to practice religion. And therefore, it says that the Supreme Court should keep its hands off the issue. This particular aspect of triple talaq is not maintainable. Then it goes on to highlight as to how this particular issue is a matter of legislative concern. It is not for the courts to adjudicate on. Further, it also goes on to emphasize, Biren, very interestingly, in a voluminous 29-page response as to how the concept of triple talaq, the concept of halala, is misunderstood, and it is submitted that where the Muslim woman is divorced, she is prohibited from marrying her former husband unless she has an intervening marriage with another man, and this concept of intervening marriage is distortedly, it says, is called nikah halala by the petitioners. So there is no concept of nikah halala in Islamic jurisprudence. So therefore, what is very interesting is, one, Biren, the opposition to the issue of judicial intervention in the matter of triple talaq continues before the Supreme Court. Like you rightly pointed out, the Supreme Court will further adjudicate the issue on the 30th of March. Interestingly, Supreme Court has also fixed for final hearing from 10th May onwards the batch of petitions on this aspect of triple talaq. So clearly the Muslim Personal Law Board does not want judicial intervention on this issue. It feels that this is an issue which is in the legislative domain. It is not for the courts to adjudicate on.